Hello.
Hello, how are you?
Mr.
Nice to
Gosney,
see you
good to
again.
see you.
Hi.
Nice to see you guys.
Hi.
Hi, yes,
Make yourself comfortable?
We'll just wait for Matt to get back.
Absolutely. You guys good?
We're live.
We're missing one.
I know. I see. All eyes on Mr. Conley.
Good afternoon.
Good afternoon.
How you doing? Just wash my hands, you're safe.
Okay. I did the same thing, so. Having just driven from Colorado, so.
Well, welcome.
Thank you.
Judge, everything's so well in county court. Tell us why you want to go to circuit.
I knew that would be a question that you all would ask me right out the gate, and honestly, this may sound strange, but I miss doing family law. So there aren't many attorneys that enjoy doing family law, and I would imagine there's even fewer judges that enjoy doing family law. And that was such a large part of my practice, and I miss working with families, and I feel like I could really make a difference in children's lives. Since December, I've been handling the delinquency cases for Judge Walsh, and I've really come to love that. And I really feel strongly about Unified Family Court. When I went to the crossover training for judges in March, it's about a 3-day crossover training that you do if you switch divisions or something like that. And that was really when I was explained and understood what Unified Family Court meant. I had never really worked in a Unified Family Court division. I did a lot of divorce cases and custody cases and child support, but I didn't really do a lot of delinquency or dependency as an attorney. So when I understood the concept of you see a child in dependency court that essentially is a victim of neglect or abuse, and then you see them in delinquency court, and then knowing that there's other family dynamics going on, having one judge who handles all of those cases, I think is a wonderful concept, and that's really something that I feel strongly and passionately about. I miss doing circuit work. Obviously, I did a lot of circuit work, both criminal and family, so I do miss the more intellectual, mixed questions of fact and law that you see in circuit court versus county court. But quite frankly, I love what I'm doing so much, so it was really, honestly, it was really kind of a tough decision for me to choose whether or not to put in for this spot, because I love my job. I love what I'm doing. I don't want to feel like the voters that I'm letting Flagler County down by trying to leave and go into a different direction, because I'm still every day in awe that the electorate of Flagler County selected me for that spot, and I'm still humbled at my position now. So I definitely don't want people to take it as I'm not challenged enough, or I don't like my job, or that was just my foot in the door. It's definitely not the case. I love what I'm doing, and I think I would love doing circuit work as well. And if I became a circuit judge, honestly, there's things about county court that I would miss. So it's kind of a mixed bag. I wish I could kind of do both, but
Let me ask you this. County circuit, do you see yourself going at any point in the future circuit to district?
I can't really imagine that now. I love trials. I mean, I slept at a jury this morning, and my state attorney knows that I'm not happy if I don't have a trial, at least one per month. I just love jury trials. So I don't know if I would enjoy reading a banker's box of a trial rather than being in it myself. So I don't necessarily see me going to that next level, but I don't know how I'll feel in 10 or 15 years. But I love trials. I love being in a courtroom. So.
Judge Stens, I had the pleasure of vetting you, and I have to say that your application was very, very impressive. And to my other fellow commissioners that maybe didn't have an opportunity to read your application, can you describe in detail some of the training that you've undergone since taking the county court bench, and also mention that you're criminal board certified, and why you chose to do that?
So, just a little bit of background. I started practicing in '98. I was a state attorney for about 2.5 years under Mr. Tanner, and then started my own practice where I did mostly criminal and family defense, criminal defense and family law. I became board certified in criminal trial in 2006, and I still have that certification. I obviously renew next year. and I've been actually able to cover some felony jury trials for Judge Walsh to be able to maintain my certification, because you have to have a certain number of felonies. So I shouldn't have any problem re-upping my certification next year. Since being a county judge, you go through your initial set of training, your first week of judge school in January, and then you go through your second week of more intensive. The first week is more how to be a judge, your demeanor, your disposition, how you're going to handle yourself in your docket. The second week is more hands-on, the actual substantive areas that you're going to be learning. And I really didn't do county civil as an attorney. So that was a huge learning experience for me, learning about county court, learning about evictions, small claims. I had never handled an eviction. I had never handled a small claims case. And I really enjoyed the process of learning and the way that judges teach other judges. So I went to school to learn how to teach other judges in November of my first year of being on the bench in 13. And I started teaching last year. I teach at the DUI Adjudication Lab, which is a week-long program that they do for judges who are entering into a DUI court division or who don't have, moving from civil to criminal or don't have any DUI background. So I teach at that. I taught last year for the first time. I'll be teaching again next month in November. And I'm also going to be teaching in July at our county judge conference on first appearances and extraditions with another judge from Miami. The DUI lab is only usually 25 to 30 participants, but the one in July next year is going to be to our entire county judge conference. So it could be about 200 plus judges who are there that I'm going to be teaching to. So I'm really excited about doing that. And I'm excited that I get to teach in July about first appearances, which is something that I feel passionate about, which is one of those things that I will miss if I become a circuit judge, because I love doing first appearances. And doing first appearances is one of those things that when, from the outside looking in, when you think about being a judge and what you're going to do and how you're going to act, I didn't really think about first appearance being such a critical stage in somebody's case, but it is such a critical stage. And I started noticing that people who were charged with retail theft with a $250 bond, or somebody with a domestic battery with a $1,000 bond, were sitting in jail for a week or 2 weeks at a time until they could get in for a jail arraignment with me. And they're getting offered diversions from the state, or they're being offered a withholding probation, which means this is not a case that the state was looking for jail time out of this person anyway, and yet they sat in our jail for 10 to 15 days because they couldn't post a $250 bond or a $1,000 bond. In my position, I am a member of the Safety Council, so I presented this to them because I knew we had pretrial services here in Volusia County. I know how successful it is, and I just found out a couple weeks ago that it's actually a model for the whole entire country, which is phenomenal to me. So I pitched the idea to the Public Safety Council, and they said, well, Judge, will you keep track of numbers and kind of crunch the numbers for us? So I started a list next to my bench. I kept track of every single person that I would have put on pretrial release, what type of case it was, what type of bond I gave them instead, and with the numbers, the Safety Council said, okay, we're going to pitch this to the County Commission, which initially they said no, and then a little money here, a little money there. We were able to start the program, I want to say about April, May of last year, and it's been a huge success. So I'm really so thankful that the county commissioners in Flagler were able to recognize that we had this need, and that I was able to make a suggestion for us to try to fill that need to help our indigent persons who were in Flagler County. Also, we have our jail issue in Flagler County, which I'm sure you all have heard something about over the last few years. So that was a motivation and a concern as well, especially when we only have capacity for 14 females, and I get the email every single day where we have 30 or 31 or 32 women who essentially are staying in a space for 14 people. So that's a heavy consideration that every single day I deal with and wake up and think about. And so if I have, not that the men aren't important, but if I have a female in front of me and I know I've already got 34 females, is this another female that I feel so strongly about that needs to be in custody, or is there another way? And I love having Miss O'Neill there. She's such an asset to our community. Everybody loves her. I mean, even after people are off pretrial release and they enter a plea, they say, I'm still going to visit Miss LaFrida because she's so sweet. And so she really helps people try to understand their case, understand the process, help them get their licenses back, help them with employment. I mean, she goes above and beyond. So she's just a beautiful person and an asset to Flagler County. So I'm happy to have been a part of that process and glad to see that it's successful and working.
Well, I had, interesting because I know for a fact that you've done circuit civil case or circuit criminal case because I have 2 appeals coming out of where you were the judge, and one of them was one that I actually got to do with a good case. And you did something in that case. It was an Anders appeal because I thought it was really interesting, and I'd like your reflection on this because the state attorney was not behaving properly in the sentencing and was throwing out a lot of stuff that my eyes were lighting up and I was getting excited about. But when you sentenced him, you said, okay, that is improper and I'm not taking that into consideration during the sentencing. And I thought that was a very wise move from the bench. You don't see that a lot of times, but that really, obviously it was an Anders appeal. But my question and that's a real tough call, I know, for a judge about when do you step into a case and sort of insert yourself when you may have knowledge because you've read the file and you are prepared, and I know that you do come to work prepared, but how much do you let the parties run the courtroom, and when do you choose to insert yourself? I mean, isn't there sort of a balance there where your opinions can change because maybe the parties on the other side also have information that you don't have? I'm just I want your thoughts on that because I love that that was an impressive thing. When I actually did a search of all my cases and I was like, well, have I ever dealt with you on any appeals? And this came out and I said, oh, I remember that. That was good. But what is your thinking from the bench? And I think you did a great job on the circuit, so you're obviously capable. But what about that balance?
I think that hits on one of the hardest parts of the job, quite frankly, is how much do you insert yourself into the proceedings and how much do you allow the litigants to bring to you. And I remember at judge school in January, it was actually a 4th DCA judge, Gerber from down in Palm Beach, had said to me, but you can't be the second defense attorney in the room. You can't just grant a motion for mistrial. And I had been in defense attorney mode for 12 years at that point, so I was like, okay, so it kind of helped me put into perspective, I really need to let the attorneys run this show. I can't interject myself and do their job for them. If they're going to object, they're going to object. And if they do, I'll rule on the objection. And I really try to allow the litigants and the attorneys to try their case in the way that they want to. If there is something that either side wants me to make a ruling on, they need to bring that to my attention because I do have that in the back of my brain of if I interject myself in the middle of something the plaintiff is saying, then they might feel that I'm more in favor of the defendant. If I interject myself in something the defendant is saying, then they're going to think, well, I'm automatically for the plaintiff. And that's not necessarily the case. So, obviously, so I try to let the lawyers and the litigants handle it as best as I can. Now, it's a completely different ballgame when I'm dealing with 2 pro se litigants versus 2 lawyers. I expect that the lawyers are prepared and know their case better than I do. And that's one of the, I'm going to go off to the side for a minute. One of the things that I love about being in county court is my prosecutors are young, my PDs, everybody's looking for feedback. So oftentimes after trials, especially if it's a not guilty, I'll bring them back and we'll talk about the case. I'll take notes. Well, why didn't you object here? And I really liked when you said this. Next time add this. And, I'll just try to help them because it's like a teaching moment for me and I really enjoy it. And so that's kind of how I feel about it is I can take notes and I can write things down, but if they're not objecting, it's not my job to try their case for them. That's what they're for. And I don't know if they're intentionally not objecting to something because they want it to come in or strategy. I don't know, and that's not my job. So I really try to be hands off. when I've got pro se litigants, it is a little bit different. So with my pro se people, if I feel like they're going down a road that I'm gonna stop them and I'll warn them, and I usually warn them like 3 or 4 times before I get a little bit strict with them, and I'll just say, you can't tell me what, usually it's hearsay, you can't tell me what so-and-so told you, I can't take that into consideration. Okay, do it again. I already explained to you that I can't take that evidence into consideration. I mean, I'm certainly not gonna hold somebody in contempt or anything crazy for something like that, but I really try to let the parties tell me what they need me to know. It's not my job to try their case. Just 2 weeks ago, I had a small claims case where a woman came in and told me what she wanted to say, and they went back and forth a little bit, and she never told me how much money she wanted. She never submitted any invoices or never any explanation as to why. I mean, in her statement of claim, she had an amount, but she has to prove that to me at trial. And I actually see that quite frequently. Do I ask, how much money are you asking for? Do I ask, are you asking for reimbursement of court costs? Is that my job?
Well, on the other hand, and I'll throw out the other side, the Cruz case, which was the one with the first degree murder trial, it's overturned based on prosecutorial misconduct. And the judge was actually, they said, the judge should have insured themselves more when this bad behavior, there was no objections, but it was fundamental because the prosecutor was so out of line. And, you know, and so I think that there is a boundary there. And so knowing that boundary, and I know we've practiced together, and I know that you know exactly what that boundary is.
Right.
I don't have absolute confidence, but it's just interesting to hear it from a judge, now that you've been in this position, you know, what the thinking goes on and how you look at things. And I appreciate your comments. Thank you.
It is really difficult. Like I said, that is one of the hardest parts of the job, is maintaining that decorum, that poker face, and not intervening in what the litigants are doing.
Sure.
So,
Judge, you were the last name out of my mentor at work. What he said to me last week, and you were the last name words my husband said to me this morning when I was leaving. And it struck me because I have a civil practice, my husband has a criminal practice. How do you balance doing both?
I guess you just, what's on your plate, you manage it and you handle it. When I came into that job, like I said, I had not done county civil at all. So that was the hardest and steepest learning curve for me. And I feel like I spent a lot more time on my county cases, on my civil cases, in the first year or so. Once I got comfortable handling trials, it's mostly non-jury trials, motions for summary judgment, motions to dismiss, evictions. Once I felt like I had enough of those under my belt, then it seemed to go a lot smoother for me. I felt like there was a learning curve there for the civil, but I enjoy it. I enjoy that part of the practice. I feel like with the civil cases, especially with lawyers, and in the application I had put down, you know, the foreclosure cases and how that's trickling into county court when it comes to condo associations or homeowner associations. Those mixed questions of fact and law can be extraordinarily intricate and are really interesting to me. So I enjoy the civil side, I really do. I didn't think that I would, but I do enjoy it.
Do you have different, are you jumping back and forth in your mind between civil and criminal, you know, in a week or in a day? Have you set up your schedule so that you have weeks of this and weeks of that?
The way my schedule is, so this is my trial week, so pretty much the only thing I have scheduled this week is my criminal jury trials. Every other week, the other 3 weeks in the month, I do arraignments, criminal arraignments, all day Tuesday. I do criminal traffic in the morning, and then misdemeanor cases, anything that needs an information is scheduled in the afternoon. Wednesdays, I usually spend most of the day doing criminal, although previously, when Judge Addick had this position, she did civil on Wednesday. I added a VOP day, so I do VOPs twice a month. I have criminal pretrials once a month, and usually motions to suppress and things like that on Wednesdays. Thursday, I have PD pretrials once a month. I have docket sounding once a month. And again, I'll usually use that for criminal as well. Monday and Friday are usually the bulk civil days. So, but then when Judge LaRue retired at the end of last year, and I knew that Judge Walsh was looking at having to take delinquency back on, I know his schedule is crazy, and he hardly has any free time. I mean, he hardly leaves the building, even for lunch anymore. So I looked at my calendar, I talked to Christina, my assistant, and I said, is there any way we can help Judge Walsh with this? And I I felt like I could sacrifice my Monday afternoons 3 times a month to help him with delinquency, because I knew it was gonna be a lot for him to take on, and I was willing to help. So we've worked that out, and Chief Judge Perkins called me and said, don't think you're giving up your county docket to be a circuit judge. I'm not gonna let you give away your county duties for that. And I said, no, if it's too much, I'll let you know, and I'll tell you it's too much, please take it back. But let me see if I can make this work, and it's been manageable. So we're doing our judicial workload study right now, and it's been super fun because most judges have either a county civil or a criminal docket, whereas I'm using like 2 pages a day because I have, you know, misdemeanor, pretrial, VOPs, and pleas in one day. And same thing with criminal traffic, and same thing with DUIs. And then I have my small claims. Pretrial, uncontested disposition if I get a motion for default or something in, and then post-judgment if I get garnishments. Same thing with small claims, same thing with evictions. So I have, my chart is ridiculous as a solo county judge, but I mean, honestly, I love it. That's why I said there's so many things about being the county judge that I love that I will miss. I feel like having the entire docket myself, it helps me. It's almost like that unified family court concept, but in a county world, because if I have somebody in front of me who's got criminal charges, they're sitting in jail, they're served an eviction, I know they're getting an eviction going on, so it's like I know what they've got going on here, I know what they have going on there. I've had people with companion, county civil, and county criminal cases, animal cruelty cases. Somebody comes in front of me, the county's trying to have the animal taken from them and prevent them from owning animals in the future, and I also have an animal cruelty case with them, criminal court. So I feel like that aspect of it is really nice in that I can see all of the cases and know what's happening without having to pick up the phone and call somebody else or look in someone else's court file. I'm familiar with the litigants, and I type notes inside our clerk benchmark system, so I have my notes in there of what I've done and what's happened in the cases, so I really find that beneficial. So I don't have a lot of time for legal research or other case administration. I'm looking at all these different categories of things that we can list for the month, and I'm like, legal research, who has time for that? I do if I have something in front of me, but I don't just sit and read Florida Law Weekly. I don't have time for things like that. I'm busy. But I love it. I wouldn't have it any other way. I love being busy.
So with Flagler County too.
I love Flagler County.
Anyone else?
Out of curiosity, 1998 through 2001, St. John's River Community College, what were you teaching?
I was teaching the legal block of the police academy. I started out the very first time that I taught, it was actually in Palatka, and I feel like it was for breath test operators. I came in and explained the breath test law, essentially refusals and things like that, and had some questions about why portable breath tests aren't admissible and aren't allowed, etc. And then they asked me to come teach over in St. Johns County, so I don't remember how many times I did that at this point, but I did it a few times.
Judge, thank you for coming in.
Thank you all. I really want to commend each of you for the amount of time that you put into these applications. I know that I had met with Mr. Green back in 2012 for probably a good hour when he was vetting other candidates, and so I know how much time you all spend, not just during these interviews, but in advance, talking to people about potential candidates. So I really want to thank you for all the time. I know you don't get a lot of publicity or thanks probably for all the hard work that you all put in, but those of us who are going through this process know how much time you put in, so I really want to thank you.
Thank you for saying that. Appreciate it. Judge, we'll let everyone know this afternoon.
Okay,
Okay.
thank you.